224 with the whole voting thing, trying to clean up things that were done in 194 in 224. That was sloppy. So we need to be more deliberative in our processes in the General Assembly.
Walk actually with Cincinnati prior. Using issue 2 as an example, polls ahead of the election, we all know, predicted that it was going to fail. But those same polls also said that the population of Ohio supported aspects of Senate Bill 5. This would essentially negate, your proposal would essentially negate the will of the people who want aspects of Senate Bill 5 enacted.
Well, I think to that, and anyone who wants to comment, I mean, you know, a poll is not necessarily a vote. And so, you know, I think that the time for us to actually have had those conversations was in the process of Senate Bill 5 to begin with. You know, whomever was driving, you know, the momentum behind Senate Bill 5, I would say was short-sighted in doing such an expansive overreach. And so, again, you know, because of the way that the referendum was structured, it was a straight-up repeal. And so, you know, in that regard, I think that with the overwhelming and decisive nature of the defeat of issue 2, it seems, at least in that context, that the public is pretty united in that concern about the overreach by the General Assembly. And I think to try to then piecemeal it back together because of polls, you know, is also short-sighted and probably not good public policy either. I mean, we can't just make you know, policy decisions based on you know, the way the wind blows either. So
should the referendum on Senate Bill 5 been better structured to limit so that it focused more on the aspects of Senate Bill 5 that folks actually disagree with, as opposed to...
I mean, that ship sailed. It's, you know, to
I'm
try
just using it as an example.
Well, as I said earlier, when this gentleman here from Toledo Blade asked about 194, I mean, I think that, you know, the people that bring forth any kind of initiative, petition, or referendum, maybe because of this 2-year cooling off period, will be more strategic, more conscientious, and more, you know, deliberate in how they structure ballot initiatives going forward. You know, hindsight's 2020, and there's no reason to have, you know, a post-mortem about issue 2 or anything else that's currently pending. But, you know, it certainly is, you know, the will of the people as well to be more specific in the kinds of things they want to change, whether it's by initiative petition because of, you know, action or inaction by the General Assembly, or by referendum for, you know, repeal.
Senator Jim, what about the flip side of this election, issue 3? Overwhelmingly, 66% of the vote. What if the courts immediately determined that Ohio had broken the law to some degree, that Ohio was not in compliance with federal law? Under this 2-year moratorium might be a problem if you had conservative Republicans who didn't care, as an example, who wouldn't budge on that supermajority.
Well, here's the one thing that I have to say about that, is that that is actually a constitutional amendment. It's not a piece of statute. We can't change it anyway. So the way that, you know, issue 3 was structured is actually, it was a constitutional amendment. So that in and of itself, in order to undo it, you have to go back to the people to amend the Constitution anyway. Secondly, I mean, you know, the facts around issue 3 are highly complex for just the reason that you mentioned, because of the federal law, because of federal preemption issues, and because of the constitutionality of the Interstate Commerce Clause. So, you know, the outcome of issue 3 is going to be, you know, stuck in the courts for quite some time. But, you know, from the perspective of this, it's a constitutional amendment. You'd have to start from scratch anyway.
If I could, I want to go back to this gentleman's question that you asked. By enacting our proposal here, precisely what you have mentioned will be avoided. A piece of legislation, perhaps that would not have been all bad on SB 5, became a Christmas tree. Everybody's wish list was put into that bill. Knowing that they cannot come back later and enact parts and portions of something which the people have spoken out against, I believe will eliminate that possibility of loading bills with everything but the kitchen sink.
Joe Inglis with Ohio Public Radio. We know that later today, some conservative-leaning groups are going to hold a news conference to talk about a right-to-work bill, and that there is actually a constitutional amendment that they want to introduce. Because that's a constitutional amendment, would that immediately not be subject to this? Or if it was an initiative instead, would it be subject to it? How would it be affected?
Sure.
Because there will be parts of that bill that have been in Senate Bill 5. Right.
I mean, again, with the constitutional amendment issue, you have a situation where you're, it has to go to the people anyway. And so if, it's strictly a constitutional amendment, if it passes, then you have to go back to the people to repeal that element of the Constitution. So this really deals with statutory changes where something happens, again, whether it's an initiative petition process like the smoking ban that changed the statute in Ohio, or if it's an issue like the referendum on Senate Bill 5 that repealed something that the General Assembly did, that's when this 2-year issue would take effect. So whether or not the group has any intention to do elements through a statutory change of initiative petition, that certainly would be a concern and an area in which this would apply. Yes, sir.
I haven't had a chance to read the bill completely, but I might assume that this does not deal with, say, a failed referendum. Say somebody issues
That's right.
a referendum and it fails, and you come back the next year and you want to try to do it again. This has no impact on.
No. I mean, if somebody wants to come back, next year and put a referendum to repeal the smoking ban, or somebody like the sick days. Okay, the sick day thing comes and goes as far as an initiative petition. If it fails and people want to come back, that's a whole different issue. Because again, the people have spoken in that regard, and it fell short.
Just to make sure I'm clear, are you talking about initiated statute as opposed to a referendum?
I'm talking about both.
Senator Siegel, Dispatch. If this were in place this year, would it have blocked Republicans from putting into the budget merit pay and the provisions on the layoffs and seniority?
I believe so. Yes. I mean, that would be, the way that I would interpret it, particularly because it was a constitutional amendment, and we are, focusing not just on whole, but parts, if you will. So I do think that it would have probably had the impact of, preventing bits and pieces of something that had been repealed, for example, to be stuffed in other bills.
Senator, it's Shane Stecknotter from Canada News Service. So if the legislature goes and passes a law, then would it be up to the people behind the referendum then to file a suit in courts to try and challenge what they did, or how would that work? How would challenges work?
Challenges work the same way that they would always work. I mean, I don't know if I'm necessarily following your line of questioning, but I mean, if someone files suit, then that process remains the same. Now it would start the 90-day clock over again, back to like the starting point, if you will, to start the signature process, if indeed the courts ruled a certain way. As far as this is concerned, just to be clear, we in the General Assembly do constitutional amendments through resolution all the time. That's actually how issue 3. That's how issue 1 and issue 3 got on the ballot. Previous elections, we've had elements of the Great Lakes Compact that we did, and so this basically would be doing a constitutional amendment that would be put on the ballot. We would do it through the legislative process. That is common. Now, if there is an action on behalf of the General Assembly, the people do have an opportunity to petition to put this on the ballot as well.
But carry that a little bit further. Would this prohibit the General Assembly from putting Senate Bill 5 on the ballot as a constitutional amendment as opposed to passing passing another law?
Yes, I think so. I can double check, but I mean, that would be, it would be my thought, because it still would be legislative action, if you will.
Senator, there are always pluses and minuses of being the majority. And someday, sooner or later, the Democrats will be the majority. That pendulum swings.
Sure.
I mean, isn't it up to the majority if they look at Senate Bill 5 and determine that there are parts of that that they want to revisit? They stand the risk with the people at the ballot box in the next election of the consequences of tinkering then with parts of the people's voice. I mean, at the end of the day, you all are legislators. Is that not what you do?
Well, if I may, and then Senator Turner, I apologize, but again, I mean, we're certainly not abdicating our role as legislators, as member of the General Assembly. Again, that's why we have a provision in here to basically, have the 2-year clock be set aside if we find that there is a necessity to do so. So if the majority decides that that's what they want to do, they have every right to try to get a supermajority of people and to stop the 2-year clock and make those changes. We do retain that right, and we try to have a check and balance, because we don't want to abdicate our role. We understand why we've been brought here, and you're kind of making the argument like term limits. It's like term limits, it's elections, I mean, but we have term limits here in the state of Ohio too. So, I mean, I hear what you're saying, but again, if that's what the majority wants, the majority can try to convince other members to go along with them and usurp that 2-year business.
And I just want to add to what Senator Cafaro said. I mean, we do understand, again, that this cuts both ways, and that's why this is not about our political affiliation or who's in power at this time. It is really about it's really about good government, and we should do this. And also, one of the major points in the legislation of the 2/3 forces us, or we shouldn't be forced, but it forces us to work together if we do want to change that. So in the case of the House right now, where they would need Democrats for a 2/3 majority, that is a good thing. Right. We should be doing that anyway. We shouldn't have to be forced. But to me, that's a highlight of the bill, that it forces a dialogue about things this big and this profound.
Do you see a need for this because we might be seeing more referendums? We seem to be getting a lot over the last couple of election cycles, or more than maybe we had in the past. Do you see more of these, and thus the need for this kind of legislation?
I think that may be part of it, certainly, but I mean, I don't think that that's the driving factor. I mean, I think that if there's any element to that is an impetus behind this, it's the fact that if indeed there are more referendums or initiative petitions that occur, there will be more opportunities, essentially, for the voice of the people to be injected into the lawmaking process. And as such, we need to make sure that that is respected within our Constitution.
If this were in effect now, could the General Assembly come back and say we want to require employees to pay 20% of their health care? If they just use a different figure, do they end up?
I don't think so. Because, I mean, and the way that we've written it, we basically try to make it as such where we're saying identical or substantially similar. So just changing a number is still substantially similar.
And who makes that call?
I mean, who knows? I mean, ultimately, it would probably, I mean, it could potentially be, brought to the Supreme Court because it's a constitutional amendment. So, I mean, there could be, if indeed the legislature tries to overreach and say, well, no, it's not really substantially similar because it's 20 and not 15, then chances are someone will file suit in the Supreme Court because, it's a constitutional issue in the state of Ohio, and there would probably be case law then that would dictate what substantially similar is.
And the pension reform bill is eventually going to come up before you. If they try to do the 12-12 proposal, is that legal?
It's a good question. Again, substantially similar would apply, and I would suspect. And so, again, that might be something that would have to be ultimately decided and interpreted by the courts, but you raise a very good point.
But it would take somebody to have to raise that in the courts. If nobody raised it, it would just go into law, correct? Someone would have to come forward and
conceivably. Because someone would have to make the argument about the definition of substantially similar and challenge the fact that it's, not substantially similar or is substantially similar. So that would be my interpretation. I'm no lawyer.